keep doing this. Then, Malas, this is followed by a constitution bench in Telpo. And for that, your lordship will turn to do this. This was
73, page 73.
Yes, Mr. Sibal read 85 and 86. I want to read, I'm not going to repeat scrupulously anything. I want to read the previous page. Printed page 84. On the top center page 84. It's also constitution bench. Well, this is the STC is a very respectable lineage. And therefore, well, it has been followed in several cases. I'm just showing some of the major ones which follows it on this point.
Yes, which page we are referring?
84 is the printed page. 84. Why are you saying that? Just keep it like that. That being the position, does my lord have it?
Yes.
That being the position with regard to the doctrine of the will of a corporation, the principle of the said will can be lifted in some cases. The question arises for our decision is, can we lift the will of the petitioner and say that it is the shareholders who are really moving the court under 32, and so the existence of the legal and juristic separate entity of the petitioner as a corporation or as a company should not make the petitions filed by them under 32 incompetent. We do not think we can answer this question in the affirmative, but there's a double negative there. They are saying it can't be maintained. In a simple language, the triple negative in fact. No doubt the complaint made by the petitioners is that the fundamental rights are infringed. And it is a truism to say that the court, as a guardian of fundamental rights, the citizens will always attempt to safeguard the said fundamental rights. Having regard to the decision of this court in State Trading Corporation. Alon has got it?
Yes.
We do not see how we can legitimately entertain the petitioner's plea in the present petition, because if their plea is upheld, it would really mean that the cooperation of the companies cannot achieve directly, can be achieved by them indirectly by relying upon the doctrine of lifting of the veil. So you can't maintain a petition otherwise, but you lift the veil and say it's nothing but the government. If the corporations and companies are not citizens, it means that the Constitution intended that they should not get the benefit of 19. It is no doubt suggested by the petitioner, though Article 19 is confined to citizens, the Constitution makers may have thought. It is no doubt suggested by the petitioners. When the petitioner said, please hold it maintainable. So they are dealing with that argument. It is no doubt suggested by the petitioners that though Article 19 is confined to citizens, the Constitution makers may have thought that in dealing with the claims of corporations to invoke the provisions of 19, courts would act upon the doctrine of lifting the veil and would not treat the attempts of the corporations that behalf is falling outside 19. We do not think this argument is well founded. The effect of confining 19 to citizens as distinguished from persons to whom other articles like 14 apply clearly must be that it is only citizens to whom the rights under 19 are guaranteed. If the legislature intends that the benefit of 19 should be made available to the corporations, not be difficult for it to adopt a proper measure in their behalf by enlarging the definition of citizens prescribed by the Citizenship Act passed by Parliament. On the other hand, the fact that Parliament has not chosen to make any such provision indicates that it was not the intention of Parliament to treat corporations as citizens. Therefore, it seems to us the view of the decision of this court in the case of STC. The petitioners cannot be heard to say that the shareholders should be allowed to file the present petition on the ground that in substance, the corporations are nothing more than associations of shareholders. Whereas the next para has been read. It's important. Just underline where lordship should read and I will not read because it has been read at the bottom of this page. Below that judgment of All India Banks Industry. That's also important. And that I will treat as having been read to save time. Then, this is followed by yet another constitution bench at page 88. The third constitution bench. British India Steamship. Only one passage at 91. Starts in 80, short judgment. Besides, it appears at 91, that these writs purport to raise a question about validity of 52A of the Sea Customs Act may have weighed in favor of admitting the matters. But as we have held in Civil Appeal 770, the foreign companies whose vessels have contravened the 52A, on which penalties have been imposed, are not entitled to claim the fundamental right. Now, this is true, it's a foreign issue. But I'm just saying, maintain with citizens alone, not foreign, not corporations, not departments. in regard to the shipping cost, so there are two categories. The previous para was foreign. This is now in regard to the shipping corporation, which was filed 3 writs. The said corporation is in no better position. As a result of the decision in STC, the shipping corporation cannot claim to be, etc., citizen not entitled to upon Article 9. Whereas Barium, a case which is very celebrated at page 92, is celebrated for the other point my Lord knows well, whereas relevant considerations, irrelevant considerations, etc. But there is in that celebrated case a para on STC also at 103. It is not cited for that purpose so much, but it is at 103. As already stated, the appellant had challenged the provisions of I'm sorry, I'm very sorry.
Just 1 minute.
I'm sorry. As already stated, the appellant had challenged the provisions of 237. That is one of the inquiry by the inspector on which your lordship had the famous laying down of law, etc. That was the old law.
Yes.
Sorry, my lord, it starts at 90.
103.
And 103. Sanjari has got it? Yes.
Yes.
As already stated, the appellant had challenged the provisions of 237 on the grounds that they are violating the fundamental rights under 14 and 19. Our brother Shellet has dealt with this attack in the provisions fully, and we agree with him generally with what he has said while dealing with the contention. However, I'd like to add, the company being an artificial legal person cannot, as held by STC, claim the benefit of the provision of 19(1)(g). It applies to department equally. Through appellant 2. We agree with our learned brother that the action proposed under so-and-so being really exploratory, the fundamental rights to carry on with this, that's a separate issue. That's a separate issue. Now, let's 2 more things and I'm done. One is, that the STC line of cases, I'm just calling it the line, it's a very respectable lineage. Justice Hidayatullah, which is the main juristically elaborate judgment, makes it clear that they are not entitled to, the corporations or departments are not entitled, I'm summarizing this, the rights of natural persons who must be citizens. Now, Articles 21, 22 and 14 have been invoked by ED. I'm just summarizing, the Lordship knows this point, but no doubt invoked. Either ED has a 14, 21, 22, which even they don't contend. I am ED, this is ED. ED itself can't contend, I have 14, 21, 22 on this. The second contention is I am the officer of ED and I have that other officer petition. It is clear, and this is important. You cannot do indirectly what you can't do directly. Now that officer petition is nothing but nothing at all. That officer has no existence, no identity, no nothing except as a person discharging the duties under the statute, is my humble submission to my Lord. He is acting as a person discharging his statutory duties. In that, he is representing, acting for, in accordance with or not in accordance with a different question, the statutory provisions. So that's my answer to that petition.
No, it's directly, indirectly principle.
Yes.
Whether it applies to administrative law or it applies to for maintaining a petition for breach of fundamental right also.
Yes. I'm very grateful for the query.
Yes.
Well, my humble submission applies to both.
Yes.
This principle of what you cannot do directly, you cannot do indirectly, is what I might submit, is only well as your Lordship is to consider making a submission, is a subject neutral principle. It's a subject neutral principle. So, if this cannot be done by this path, if I am able to show, obviously I have to show that, otherwise it won't work, that the alternative path is nothing but a camouflaged version of the same path, then your Lordship will apply the principle, subject neutral. Public law, private law, this is a principle of equity. Well, for example, your Lordship has another principle of equity, cannot take advantage of own wrong. I'm just giving an example. There is a judgment called Priyanka, which very deep. Third principle, you cannot say X and directly in the next sentence or the next paragraph or the next case before the same bench say Y, the opposite. These principles, very important query from my Lord Mishra, I'm answering this to the best of my ability, apply subject neutral. They don't apply in administrative law, disapply in contract, reapply in tort, and then again not apply in constitutional law. These are equitable principles meant for safeguarding the court
Subject
itself.
neutral and rights neutral also.
It's new across, absolutely. I mean, I cannot make a selective. If it applies, obviously, fellows, factual inquiry the judge makes whether it applies or not is the judge's prerogative. Your Lordship may say this path A is not a camouflage for B. That's the answer on facts. But the moment your Lordship comes to a finding that substantively the attempt is to reach the same goal by a camouflage, by an embellishment, by something or the other, we all know that, then my answer can't be selected. To my Lord's straight answer, the question, the answer has to be straight. That it may apply across. You call it rights, you call it liabilities, you call it duties, you call it subject. It has to be. Otherwise, your Lordships, these are self-protective, equitable principles. For example, the government says, you do this. I do this. And the government then penalizes. Taking advantage of your own wrong. Another principle, law cannot compel me to do the impossible. Department X says do this, Department Y penalizes me for doing that, etc., etc. These are, the Lordship rightly puts it, rights neutral, subject neutral, principle neutral, case neutral, if they apply, if they arise. Now, therefore, this is, and also lastly, they raise 14. So 21, 22 I've dealt with. ED raises 14 also. 14, arbitrariness and inequality neither arises for either the officer acting in the discharge of his duties, nor for the department. That's simple. 14 is either the classification doctrine of equality or the doctrine of some arbitrariness. Now, of course, the Lordship has gone in those Joseph Stein and all those cases into substantive due process, etc. Maybe. None of them arise for an ED department or for an officer in this case. Then, there is one case, a very old, venerated case, which I want to, it's really one of the first, those Article 14 cases, Part 3 cases. That's Charanjit at page 537. Is it printed 537? Same volume? Your Lordship, same volume, 537. Please come here. Very nice to know, that 1950 is now supplied by STC.
Yes.
Lordship will never get this title on any case. You'll always look at SCRs or AIR.
But the only difficulty is paragraphs are missing.
That's true. That's true. That will change. Charanjit was actually the first case after the functioning of the Republic was of a major kind in terms of this article. This was the doctrine of classification, is known for that.
Yes.
Now, if your Lordship comes to paragraph 13, which is at 563, I'm only reading some portions from my point, because I'm not going to the. It's a very detailed judgment, because those days the law was not developed. Article 14 is literally a baby. The application, I'm interested from Placitum B.
563.
Yes, the relevant part, paragraph 13. I'm interested from Placitum above Placitum B. But I will read the whole paragraph for completeness.
Yes.
The application before us under 32 is on behalf of an individual shareholder of the company. 32, as its provision shows, is not directly concerned with determination of constitutional validity of particular enactments. What it aims at is the enforcing of fundamental rights guaranteed by the Constitution, no matter whether the necessity for such enforcement arises out of an action of the executive or of the legislature. Now, this is the part your Lordship may consider emphasizing as far as I am concerned. To make out a case under this article, it is incumbent upon the petitioner to establish not merely that the law complained of is beyond the competence of the particular legislature and not being covered. So that's the legislative competence test, the noun validity. But that it affects or invades his, mark the word his, fundamental rights guaranteed. That's the word his, of which he, again he, could seek enforcement in an appropriate writ. The rights that could be enforced under 32 must ordinarily be the rights of the petitioner himself. Well, one exception is PIL. Lordship has everything. It's not that a Lordship is without any remedy or without power. The Lordship is fashioned PIL. When a Lordship wants some particular jurisdiction, Lordship has that jurisdiction. Rights of the petitioner himself, who complains of infraction of such rights and approaches the court for relief. This being the position, the proper subject of our investigation would be what rights, if any, of the petitioner as a shareholder have been violated by the improved legislation. We are far away, He's talking about shareholder rights. We are talking about departments, right? Yeah. Well, Justice Fazal Ali, this is Justice Mukherjee and Justice Kania, authored by Justice Mukherjee. Justice Fazal Ali in para 52, page 574, says this: the directness and the personalized nature are emphasized by Constitution Bench in the first year of our republic. The directness and the personal nature are the two aspects I'm emphasizing. And this is held good for 75, 80 years now. Para 52. It has been held in a number of cases in the United States of America that no one except those whose rights are directly affected by a law can raise the question of constitutionality of that law. This principle has been very clearly stated. It is an elementary principle that in order to justify the granting of this extraordinary relief, the complainant's need of it in the absence of an adequate remedy must clearly appear. Complainant cannot succeed merely because someone else may be hurt. Only exception PI. My lord stated it. Same law otherwise here, upheld till now. Nor does it make any difference that other persons who may be injured are persons of the same race or occupation. On that statement of law, which I entirely agree, the scope of the discussion is greatly restricted. Justice Fazali says that. Justice S.R. Das speaks at page 595 at para 120. Fourth line, I read the whole. I read the second sentence on this. Third line. My lord has got below.
Para?
595 is page, 120 is para. Third line, your lordship turn to. After the 14th Amendment, etc. If such be the requirements of law in connection with the Equal Protection Clause, which corresponds to our Article 14, it appears to me to follow that only a person who is the owner of the property can raise the question of constitutionality under so-and-so of a law of which he is so deprived. If direct interest is necessary to permit a person to raise the question of constitutionality under 14, a direct interest in the property will, I apprehend, be necessary to entitle a person to challenge a law. So two things, Malas. Himself, identity, and directness of interest. They both fuse. Then, Malas, may I try and conclude now? Let's just summarize my principles. You should have seen enough law, Malas, here and there with the citing law. So my submissions are, Malas. A, I'm just giving Malas points if Roshi doesn't mind. ED has no fundamental right to investigate. We're looking from all angles. So one is, I have a fundamental right under Part 3 to investigate. Sorry, no. No such fundamental right has been created by our lordships in any form, in any manner, at any time. Second, its office, so first is ED has no fundamental right to investigate. Second, its officers have no fundamental right to investigate.
Yes.
Three, there is no claim of a representative capacity which can arise because you are governed by statute, especially section 8(6) and 8(8) of the PMLA. This is not some kind of a civil action where order one rule hit principle will apply. It's a criminal action, investigation, no question. Fourth, ED officer theoretically as a human being can have a 21 right. I'm not saying that you are, well, suppose the ED officer, not in the discharge of his statutory duty, is driving along and somebody starts beating him up, state action. Nobody is saying he doesn't have a fundamental right. But an ED officer acting as an officer in this investigation, investigating her, cannot claim a separate right that which my department doesn't have the right, the statute doesn't have a right, but I have a right. That's the point I make. So don't misunderstand me. I'm not suggesting the human being can't have a right in a hypothetical case. Then, these are 4 points. Fifth point. Parents patrie, a completely erroneous principle pressed into service. Completely and thoroughly erroneous in a criminal investigation involving Part 3 issues. Will apply only when the affected party comes through some kind of a marginalized or deprived situation ED can hardly claim the protection of parents. It is itself the parents' patrimony. As a matter of fact, there is no greater authority today in the country except ED. How can ED claim somebody else's parents' patrimony? I will make an aside. Don't misunderstand me. Aside. We were discussing the other day in court also that how is it possible that sensible people are having this digital arrest? I'm not talking of case X or Y. It is incredible.
Yes.
People we know who are otherwise normal people, who are retired management consultants, US returned senior citizens, are under digital arrest for 5 days, for 5 weeks. Which means, the wife doesn't talk to the husband doesn't talk to the wife, and they don't go out socially. This is your lordship is read in the paper every day. So, I said jokingly, it is 90% cases because of terror of the caller who only cites one authority. Your lordship knows.
Yes.
The telephone call doesn't cite the younger brother.
But that's not true. I'm sorry. There are maximum cases of local police.
No, very well.
Maximum cases.
Very well. Let me
That's
give
not
my example.
political platform.
Very well. Political platform or not.
Yes.
We also read newspapers.
Fake uniform of a
There is
local
a
police.
vast difference between the terror created by the local police and when the caller says ED, and we know it, we read every day.
So in this case, who was under digital?
I said parents' patry. I started by saying, don't bother. Parents' patry is the last refuge to an authority like the EDs, all that I'm saying. They are considered the parents' patry, the big boss.
There can be several parents.
Of course, that's all. I'm not suggesting in this case.
I spoke about who in this case is the parent.
Very well, very well. Well, your lordship is discussing maintainability at the moment. It's not your lordship is. And then, lastly, last point. What are your prayer? Your lordship has seen the prayer many times. Prayer to CBIs to investigate. Where is the fundamental right for an authority like an ED asking the CBI that under my exercise of a fundamental right as a part, I can ask you, the court, to please direct the CBI to investigate? That's very far-fetched. With great respect. But those are my submissions. Very deeply obliged for the accommodation. I took time in between because I was on legs.
No,
I'm deeply obliged.
in a matter like this, it happens.
Deeply obliged.
We have to accommodate.
Grateful manage. Excuse my absence now.
I'll be
We are not
going
arguing.
next.
to argue.
Who appears for whom, Lord? It may not happen that one party is represented by two.
I don't know
for
why.
DGP. I said so last time when you
No,
objected.
I'm not objecting to
I
you.
appeared for DGP.
Because Mr. Sibal argued,
No, we have noted you appear.
everyone argued. I don't mind not anybody. Nothing would be added. But
He is not the gatekeeper of.
I think the
people
part of the
argue.
problem arose because the
anyway, but
he did not
let's not
realize he made a lot
Bengal
of
here.
respondents. He made a lot of respondents.
But I
Yes, so
appeared
wait
for
for your
the
respondents.
smallest. I appeared for the smallest. I
So wait
appeared
for
for the
the
DCP. So I was.
Anyway, but them arguing, they're arguing. I'm only on the question of wasting time. Two people arguing for the same client may waste time. That's all.
Well, we have made lots of respondents. I'm sure we are entitled to present our case.
But I think,
Yes.
I think God, my learned friend, the solicitor, with his usual generosity, will allow us to start. With his usual generosity.
Now, may it please my lords. My lords, on the issue of maintainability, and I'll start with that before I hand over my propositions, my lords. I think it's only fitting, my lords, that when the lordship said that when
You are appealing for
I appear for R2, my lords.
in which petition?
My lords, in the main petition. Main petition. Now, before I hand over my propositions, my lord, your lordships are confronted with a seminal case which tests the efficacy of a citizen alleging violation of Part 3 rights. And I say that because within the Constituent Assembly,
There appears to be a mistake because Mr. Sibal appeared for R2, if I'm not mistaken.
my lords, I'm sure we can have two people here for R2. The state is also there.
Respondent is concerned.
But it is not proper. Two people can, council cannot argue for this.
My lords, the state is also
Otherwise,
there.
if two is permissible, three is also permissible.
The state is there, the commissioner of police is there. We are making arguments on
You
maintainability.
cannot start arguing and then choose your client for whom you will be arguing.
Mr. Kalyan, that is also.
State.
Maybe there's a mistake. All of
Well,
this is a mistake.
Raju,
We are tapering
Under the
somebody else.
Supreme Court rules, two counsel can appear for party. Under the rules of the Supreme Court. Be that as it may.
Here and argue also.
Yes, but
Where is the rule? Let us see. Let's see the rule.
my lords, there is also the state of West Bengal. There is also the commissioner of police, my lords, who has not appeared.
No, if this is the rule, we can allow. In a given case,
You can divide the.
you see, in a given case,
The rule is there which
which
shows that
parties want to finish, but we don't want to get finished. We will
but
allow many.
we want to be able to argue before your lordships. The commissioner of police has also not appeared. And your lordships, I know, would want to hear arguments for such a significant issue in constitutional law. I'm not on the politics of anything.
Yes, yes, you argue, please.
Yeah.
Please.
But can I take permission, come back in Dubai? Can I come back? Lord?
Yes, yes, come back, come back.
That's just
And
permission.
tell her not to finish and before you come back.
But I'm sure your lordship, asking questions will keep her occupied.
Yes.
I'll be back.
Yeah, may I just,
Yes.
my lords? I want to start where perhaps all conversations on the constitution should start, in the debates. If you will, my lords, in the debates of the. So may I just hand over, my lords, the Constituent Assembly debates, Thursday, 9th December 1948. My lords,
But on a
please,
lighter note, before she starts, whenever the respondents try their best, even starting from pre-independence, that reject it at the threshold, don't go into the facts of the case, is a first and foremost evidence that facts are really troubling.
surprised that the
You
Yes.
solicitor.
Yes.
We will not
I'm
stop you,
surprised.
like we are not stopping you.
Yes,
We will
I'm
not stop
surprised
you
the
also.
solicitor
no, we
have
will not. We
You
will
proceed
be
in your
confined, my lord.
problems with the
It's not-
constituent debates.
You
being
proceed in
held.
your own way.
I'll
And place
we will
all
be
the-
brief.
all
We
the
will be
facts.
brief. We know, my lord, what are the contours of the matter. We are not, my lord, we are addressing only your lordship.
No, we are not saying.
The solicitor seems
We are-
very skeptical of the
What we are
constituent
saying
debates,
is
ma'am.
that if the facts are, you see, so vivid, you please tell us the facts also. Yes.
Yes, may I, my lords?
Hmm.
Your lordships will please see, my lords. This is the constituent debates, 9th December. 9th December 1948.
Mhm.
My lords may please go to my lords. This is the Honorable Dr. B.R. Ambedkar discussing what would become Article 32 of the Constitution.
Yes.
Yes, my lords. Your lordships will see this will be page 1, 2, 3, 4, 5, 6, my lords. The 6th page. It says so, my lords, right on top. The Honorable Dr. B.R. Ambedkar. Yes, the words, directions, and orders are there. My lords have that.
Yes. Page 33.
Page 33. Yes, ma'am. Page 33, right on top.
Yes.
My lords has that? Yes. My lords, may I just take you to the last paragraph on the page? And what is being discussed in 1948 as the country confronts partition, the lordships are aware, and the constitution is being crafted by the Constituent Assembly. And we start in cases like this when we're trying to interpret the intention and the cause of a textual provision of the Constitution by grounding it in what inspired its formulation. Please see. My lords has the last paragraph.
Yes.
Yes. My friend Mr. Sarvati said that while exercising the powers given under this article, and this is article, what would become Article 32, my lords. The court should have the freedom to enter into the facts of the case. I have no doubt about it that Mr. Sarvate has misunderstood the scope and nature of these writs. I therefore think that I need make no apology for explaining the nature of these writs. These are the 5 writs under Article 32. Anyone who knows anything about English law will realize and understand that the writs which are being referred to in the article fall into 2 categories. They are called in one sense prerogative writs. In another sense, other case, they are called writs in action. A writ of mandamus, a writ of prohibition, a writ of certiorari can be used or applied for both. It can be used as a prerogative writ, or it may be applied for by a litigant in the course of a suit or proceedings. The importance of these writs, which are given by this article, lies in the fact that they are prerogative writs that they can be sought for by an aggrieved party without bringing any proceedings or suit. Ordinarily, you must first file a suit before you can get any kind of order from the court, whether the order is of the nature of mandamus, prohibition, or certiorari, or anything of the kind. But here, so far as this article is concerned, without filing any proceedings, you can straight away go to the court and apply for the writ. Page over. The object of the writ is to really to grant what I may call interim relief. For instance, if a man is arrested without filing a suit or a proceeding against the officer who arrests him, he can file a petition to the court for setting him at liberty. It is not necessary for him to first file a suit or a proceeding against the officer. Now, if your lordship skip 3 lines and come to all that the court can inquire in a habeas corpus proceeding is whether the arrest is lawful and will not enter into the question, at least that is the practice of the court, of the merits of the law. When a person is actually arrested and his trial has commenced, it is in the course of those proceedings that the court would be entitled to go into the facts and to come to a decision whether a particular law in which a person
Yes, yes, please.
all that the court can inquire, my lords, in a habeas corpus proceeding is whether the arrest is lawful, will not enter into the question, at least that is the practice of the court, of the merits of the law. When a person is actually arrested and his trial has commenced, it is in the course of those proceedings that the court would be entitled to go into the facts and to come to a decision whether a particular law under which a person is arrested is a good law or a bad law. Then the court will go into the question whether it conflicts with the provisions of the Constitution. Consequently, the amendment moved by my friend Shri V.S. Sarvate, if I may say so, is quite out of place. It is not here that such a provision can be made. If he refers to Article 115, he will find that a provision for similar writs have been made there. But those are the writs which can be issued in connection with questions of fact and law. They would certainly be investigated by the courts. Now, so I'm very glad that the majority of those who spoke on this article have realized the importance and significance of this article. And this is important, my lords, and your lordships may mark this. If I was asked to name any particular article in this constitution as the most important, an article without which this constitution would be a nullity, I could not refer to any other article except this one. It is the very soul of the constitution and the very heart of it. And I am glad that the House has realized its importance. There is, however, one thing which I find that the members who spoke on this have not sufficiently realized. It is to this fact that I advert before I take my seat. These writs to which reference is made in this article, in a sense, not new. Habeas corpus exists in our criminal procedure code. The writ of mandamus finds a place in our law of specific relief, and certain other writs which are referred to here are also mentioned in various laws. But there is a difference between the situation as it exists with regard to these writs and the situation as will now arise after the passing of this consultation. The writs which exist now in our various laws are at the mercy of the legislature. Our criminal procedure code, which contains a provision with regard to habeas corpus, can be amended by the existing legislature. Our specific relief act also can be amended, and the writ of habeas corpus and the right of mandamus can be taken away without any difficulty whatsoever by a legislature which happens to have a majority, and the majority happens to be a single-minded majority. Hereafter, it would not be possible for any legislature to take away the writs which are mentioned in this article. It is not that the Supreme Court is left to be invested with the power to issue these writs by a law to be made by the legislature as its sweet will. The Constitution has invested the Supreme Court with these rights, and these rights could not be taken away unless and until the Constitution itself is amended by means left open to the legislature. This, in my judgment, and this may be marked, my lords, this, in my judgment, is one of the greatest safeguards that can be provided for the safety and security of the individual. Your lordships will see this. The safety and security of the individual. We need not therefore have much apprehension that the freedoms which this Constitution has provided will be taken away by any legislature merely because it happens to have a majority. And my lords, then there is a discussion here about directive principles and fundamental rights. Your lordships will see, and there is a comparative conversation. So your lordship will see that this part is particularly clarifying. It's illuminating as to who and what was intended to be the beneficiary of Article 32 rights. It is an individual or a citizen who is looking to enforce her fundamental rights against whom? Against the state. Now, your lordships will see, my lords, and I'll in a little bit hand over specific propositions. But before I do that, may I just take you, my lords, to the Government of India Act 1935. My lords, may I have a sip of water? Thank you.
Right.
They don't need it. And we'll give a list of all the documents and readings handed over, my lords. We'll make it simple, and we'll file it also eventually at the end of submissions, my lords. When your lordships is reserved judgment, we'll file the submissions, we'll file all the documents, my lords, in neat compilations.
Yes.
Yes. Now, your lordships will see the Government of India Act 1935. I have not printed out all 343 pages of it. I have only printed the arrangement of sections. Your lordships will see, and this is the act that the nationalist movement called the slave constitution. Because you can have constitutions, and within those constitutions, you can be enslaved. Now, if you will see the big difference between the arrangement of sections part of the Government of India Act 1935 and the Constitution of India 1950, perhaps the biggest difference, even though there are a number of similarities, the biggest difference is what Dr. Ambedkar called the very soul of the Constitution, Part 3. And the enforcement mechanism of that soul, which is Article 32. So, therefore, the context which Dr. Ambedkar discusses in the passages I read to you, that why is it that you have Article 32? It is so that even if you have legislatures in majority, even if you have political parties in majority, you will have this part and this trigger. This is the trigger for the citizen in constitutional India to be able to enforce her fundamental rights and nothing else. That is the intended prescription by the drafters of India's constitution of Article 32. And therein lies the big difference. That is the constitutional revolution that was brought in by the drafters of our Constitution 1950 as compared to the Government of India Act 1935. Now, if your lordships find that the officers of the enforcement directorates can move an Article 32 petition before your lordships as officers of the enforcement directorate, not as individuals and not as human beings, as Dr. Singhvi discussed, then your lordships are actually entertaining a situation which was not intended by the framers of India's constitution. Because the ability for interdepartmental issues within the state to be triggered by Article 32 weakens Part 3 for all citizens in this country. And that will be the legacy of an argument like this. Now, your lordships, may I just take you, my lords, to Part 3. Where are the propositions? Are coming? What? May I just hand these over, my lords? Now, what is the nature, my lords, of Part 3 rights? And from this, I'll take your lordships to Keshavananda and then hand over the propositions. If your lordship sees the scheme of all of these Part 3 rights, 14, 15, 16, 17, 18, 19, all of them, my lords, are actions pertaining to the state. 14, the state shall not deny to any person equality before the law or equal protection of the law. 15, the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth. 16, there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. 17, 18, abolition of titles. No title not being a military or academic distinction shall be conferred by the state. There is nothing in Part 3, and I can read every article to you. There is nothing in Part 3 which is intended to enable interdepartmental warfare or the state to trigger a Part 3 right as a victim and not a constitutional wrongdoer. That is unenvisaged by both the drafters of India's constitution and, my lords, most importantly, the text of India's constitution. The schematic arrangement of the text of India's constitution is that these are rights against the state. The state does not get to be the victim when triggering a 32 petition. And the text of Part 3 articles are very, very clear. Now, my lords, may I just hand over a list of propositions? May I just read them, my lords?
Yes.
I'm grateful, my lords. Article 32, I have 6 propositions, my lords. Article 32, the very soul of the Constitution, this is Dr. Ambedkar being quoted, as a remedy, can only be triggered by individuals, by citizens, for violation of their Part 3 rights. 2, the state cannot simultaneously occupy the position of a constitutional wrongdoer and a victim. 3. The writs under Article 32 envisaged as remedies for rights enforcement illustrate the character of their usage against the state or courts. 4. The Supreme Court has in contemporary times reined in the Enforcement Directorate for overreach in the context of privacy, ownership of information, attorney-client privilege, search and seizure powers. And I'll take your lordships to recent decisions of the Supreme Court doing so. 5. The constitutionally appropriate party here, the union government, if in dispute with the state, ought to proceed under Article 131 of the Constitution. And 6. Questions relating to character of Article 32 writ jurisdiction, union state dispute, etc., qualify as substantial questions of law and hence trigger Article 145(3), mandating a reference to a larger constitution bench. So, lordships will see, my lords, these are the 6 propositions that I will advance and seek to place before my lords. And these are on maintainability. Now, my lords, may I just hand over my second handout? This is Keshavananda Bharti versus State of Kerala. Abridged, my lords, not the entire decision. It's 2 specific pages, my lords, pages 165 and 167. Yes. My lords will see, my lords. I'd only trouble your lordships with pages 165 and 167. This is the majority, my lords, in Keshavananda. Justice Sikri, Shellac, Hegde, Grover, Mukherjee, Reddy, and Justice Khanna. Now, may I take you, my lords? 65. This is the second page. Bottom of the page, please.
Yes.
The trouble, my lords, with 2 pages. My lord sees this. The basic structure. This is the court, my lords, arriving at these conclusions. The basic structure, my lords, has that bottom of the page, may be said to consist of.
Yes.
Yes. My lords, may please mark this. The basic structure may be said to consist of the following features: supremacy of the Constitution, republican and democratic form of government, secular character of the Constitution, separation of powers between the legislature, the executive, and the judiciary, federal character of the Constitution. The above structure is built on the basic foundation of the dignity and freedom of the individual. This is of supreme importance. This cannot, by any form of amendment, be destroyed. So your lordships, my lords, will then come down to the next page, my lords, page 167. My lords has that 1 page over, my lords. This is Justice Sikri writing this. And what is the context of this, my lords? The context of this is how do we understand fundamental rights? That is the context. My lords, 3rd paragraph, middle of the page. This is Anjarya has that. Thank you, lords. Various decisions of this court describe fundamental rights as natural rights or human rights. Some of these decisions are extracted below. And I'll quote, "There can be no doubt that the people of India have an exercise of their sovereign will, as expressed in the preamble, adopted the democratic ideal, which assures to the citizen the dignity of the individual and other cherished human values as a means to the full evolution and expression of his personality. And in delegating to the legislature the executive and the judiciary their respective powers in the Constitution reserve to themselves certain fundamental rights, so-called, I apprehend, because they have been retained by the people and made paramount to the delegated powers. Now, the point being, my lords, that there are certain natural rights that are inherent to citizens and individuals in this country. And those natural rights are captured in Part 3. And therefore, when those rights are being trampled by the state, you trigger Part 3 violations or fundamental rights violation. And therefore, for the state to argue that its Part 3 rights are being violated is not just unintended by the constitutional text, by the drafters of the Constitution, but also by the largest bench that this court has ever constituted in Keshavananda. Now, may I just take you, my lords, to page 817. My lords, at the bottom of the page, my lords. May I just take
Yes.
I have rights. Your lordships will see
Yes.
the indented portion in quotes at the bottom of that page.
Yes.
My Lord Justice Anjaria, I say 817, my lord. Sorry, 817.
Yes.
Yes. My lords, bottom of that page in italics. And this is what Justice Matthew is quoting in Keshava. I have rights which are inherent in me as a member of society, and I judge the state as the fundamental instrument of society by the manner in which it seeks to secure for me the substance of those rights. And my lords may please mark this, in which it seeks to secure for me the substance of my rights, of those rights. Rights in this sense are the groundwork of the state. They are the quality which gives to the exercise of its power a moral penumbra. And they are natural rights in the sense that they are necessary for a good life. So your lordships will see, my lords, that what the Constitution bench in Keshava is trying to do and make clear is that
This is something said by Harold Lasky,
yes, my lord,
which is quoted.
yes, my lord, which Justice Matthew is quoting, my lord. My lord. And he is discussing on page 817, the second paragraph. Despite these attacks, the ebb and flow of its fortune, there has been a revival in the law of nature in the 20th century. Lordships also, my lords, quote and speak to the political context of the moment, my lords. And in this case, Justice Matthew is doing that in the political context of that moment. But what binds us from this time to that time behind and to the framers' time is that we have a moral constitutional understanding. And that understanding is that Part 3 rights are natural rights. They are in the nature of what cannot be taken away. And when they are taken away from citizens, the citizens can trigger a 32 and come to your lordships, not the state. That is what is a thread that binds these three political times and moments of constitutional history. Now, my lords, I'll take your lordships to a case, Ujjam Bai versus State of UP, my lords. This is 1962 Supreme Court cases, SC 8. And my lords, we'll give a list of all of these citations to make it easier, my lords. Paragraph 99, my lord. I'll trouble your lordships with one paragraph alone.
Yes.
Yes. Your lordship sees this, my lords. Paragraph 99 is on what is page 39, my lords, top of the page. Paragraph 99, my lord. My lords, we've just printed the top page.
Yes.
And this is Justice Subbarah's decision starting at, my lords, paragraph 94. And this is a conception, my lords. Fundamental rights, and I'll read it very briefly, my lords. Fundamental rights are enshrined in Part 3 of the Constitution as the paramount rights of the people. Article 13(2) prohibits the state from making any law which takes away or abridges the rights conferred by the part and declares that any law made in contravention of this clause shall, to the extent of the contravention, be void. These rights may be broadly stated to relate to rights of equality, rights of freedom. So equality, my lords, 14 to 18 is the chart I handed over. Rights to freedom, articles 19 to 22. The right against exploitation, articles 23 and 24. The right to freedom of religion, articles 25 to 28. Cultural and educational rights, article 29 and 30. Right to property, 31 and 31A. Right to constitutional remedies, articles 32 to 35. These are the inalienable rights of the people of this country, some of them of non-citizens also, for instance, 21, my lords, believed to be necessary for the development of the human personality. They are essential for working out one's way of life. In theory, these rights are reserved to the people after the delegation of other rights by them to the institutions of government created by the Constitution, which expresses their will. And you can see, my lords, below, see the observations of the great judge, my lords, Patanjali Shastri, as he then was in A.K. Gopalan, State of Madras versus Srimati. And then again, the same principle is extracted there. Your lordships will see at the bottom of that page. I won't trouble my lords, but my lords may please just mark it. Yes. My lords, now may I take you, my lords, for a very lovely decision, my lords, Motilal versus the government of the state of Uttar Pradesh. 1950 SCC online, Allahabad 197. Yeah. Your lordship will see, my lords, this is a full bench, my lords. My lords has this on the top of the page, the full bench, my lords, Honorable Justice, Chief Justice Malik, Justice Mutam, Justice Banshu, Justice Sapru, and Justice Agarwal.
Yeah.
And the decision, my lords, pertains to the right of a user to the highway. Now, please see, my lords. And here, a writ of mandamus was sought. Now, please see, my lords. May I take both my lords to page 387. Bottom of the page, my lords. My lords has this second last paragraph. The insertion of fundamental rights in the Constitution is thus a deliberate departure from British concepts. And it is necessary to seek the reasons for it, particularly as they limit the sovereignty assigned to Parliament. My lords, may I just stop here for a second? This is a very big departure because the British Parliament is unchecked. Parliament is sovereign. Judicial review is constrained. In this country, all institutions are checked by the Constitution, including Parliament. The history of the evolution of thought on the rights of man takes us back into the 17th century or even earlier. From the time of Tom Paine's Rights of Man, Jefferson's Declaration of Rights, Rousseau and the French Revolution, schools of thoughts have existed, down to H.G. Wells' and discussions on human rights, which assert that man has certain natural or inalienable rights, and it is the function of the state, in order that human liberty might be preserved and human personality developed, to give recognition and free play to those rights. Fundamental rights were practically to be found in every constitution that came into existence after World War I. After World War II, as a result of the discussions on the proposed United Nations Charter of Human Rights, they have become even more visibly important in most constitutions framed after the war. So this understanding is a universal understanding today, Your Lordships, that fundamental rights which inhere in all citizens of each state after World War II cannot be trampled upon by the state, and it is the state that is being, it is the citizen that is being protected from the state. What the union here seeks to do is to try to undo this understanding. It is not just a 75-year-old understanding in constitutionally free India, but it is an understanding accepted the world over, especially, my lords, in post-colonial states that have suffered colonization. We know that our citizens must always be protected from the state, and therefore we have something like a Part 3. My lords, may I now take you to Mr. C. Banerjee. Now, may I take you to paragraph 7.4, page 350.
Yes.
Yes, my lords. My Lord Justice Anjaria has it, my lord. May I read, my lords? Thank you. By defining the state and law very widely, and this is Mr. Sirwai's understanding, my lords, and his book is still the authoritative book. It is actually an authoritative insight into the Constitution as opposed to a commentary, a case commentary. By defining the state and law very widely, the founding fathers ensured that fundamental rights operated over the widest field. The declaration in Article 13, 1 and 2, making laws inconsistent with or contrary to fundamental rights pro tanto void, would not by itself prevent the state from violating fundamental rights. To effectively prevent the state from violating fundamental rights, the founding fathers created a new fundamental right by enacting Article 32, which guaranteed the right to move the Supreme Court for the enforcement of fundamental rights. Article 32(2) armed the Supreme Court with power to issue appropriate writs, orders, or directions to prevent a violation of fundamental rights. Now, may I just take you, my lords? May I just take you to paragraph 16.84. 16.84, my lords, which is the last page, page 1493.
Yes.
Now, please see, my lords, and this is where Mr. Sirwai very nicely shows us the difference in our constitutional state and what was. And the union, what they're asking for, takes us back to that time, pre-constitutional India. Please see. Mandamus does not lie against the crown, 16.84. That there can be no mandamus to the sovereign, there can be no doubt, both because there would be an incongruity in the queen commanding herself to do an
Crown,
act.
my lord, my lord, are the respondents crown? I'm sorry, my lord, let her continue. My lord, this helps. Fortunately, we are in a democracy. My lord, nobody is a crown.
Mandamus does not lie against the crown.
Yes.
That there can be no mandamus to the sovereign, there can be no doubt, both because there would be an incongruity in the queen commanding herself to do an act, and also because disobedience to a writ of mandamus is to be enforced by attachment.
Who is the queen here?
My lords, here the state is saying that it is the victim, and Mr. Silva is showing that this is a time distinct from there. That here, that was a time where writs did not lie. This is a time where writs lie against the state, which may be an elected government, but again is still the state. That's the point. If the solicitor had taken a copy of the handout, he may have seen that. But since he's chosen not to take any handouts, then who will explain, my lords? Now, my lords, may I just take you to the next part, my lords? Which is that the states, my lords, cannot simultaneously. This is proposition 2, your lordships has on the list of propositions. 2 and 3, my lords, may just mark this. That the state cannot simultaneously occupy the position of a constitutional wrongdoer and a victim. And that the writs under Article 32, envisaged as remedies for rights enforcement, illustrate the character of their usage against the state or courts. So against the state or courts, my lords. My lords, these are a table of the kinds of writs that are triggered by Article 32.
No.
No, sir. I don't want to read you my tell. Now, my lords, may I just very briefly, I'm not going to read the whole thing, but very briefly. These are typically what are called the 5 prerogative writs that are issuable under Article 32. Please see the nature of the writs, my lords. Habeas corpus, mandamus, certiorari, prohibition, quo warranto. Now, habeas corpus, the first one, my lords. May I just read the first line?
Yes. Habeas corpus, yes.
A writ, my lord, should we continue after lunch, my lords? Would your lordship prefer that?
Yes.
Very well. So I'm so grateful.
Yeah, during the recess, my lord, we will also revive our knowledge of writs. My lord. We used to study this in first law. Very elementary.
It's still the law, my lord,
Yes,
fortunately. It's still the law.
Right, my lord.